Hello, I'm Bud Verfalli, and I'm the president and founder of Victory Fiduciary Consulting. The purpose of this video is to alert 401k plan trustees and plan administrators of some very important, even vital information about recent disturbing developments in 401k regulations and court rulings. The very fact that you may not be aware of this information should be cause for attention and review. First, let's start with the Supreme Court ruling of LaRue versus DeWolff in February 2008. This set the precedence where plan trustees' personal assets are now exposed due to plan deficiencies and mismanagement. No more corporate veil of protection for 401k trustees. Consider there are now over 1 million licensed attorneys who are filing over 70,000 lawsuits per day in the United States. Many are targeting small to medium-sized business owners and mid to upper income Americans. This certainly has changed the entire landscape for 401k plan trustees and administrators. Imagine just one disgruntled employee who wishes to assert their dissatisfaction with their 401k plan could single-handedly wreak havoc on a company's solvency. Imagine a business owner's personal assets, such as your personal home or perhaps a second home, cars, or even funds set aside for your family's college and wedding plans, can now be subject to lawsuits. It only takes one individual that could represent a group of others and thereby evolve into a class action lawsuit. The floodgates of litigation have been opened, targeting you, the 401k plan trustee or administrator. The litigation tsunami is now on the horizon. Unfortunately, in the not too distant future, look for the television commercials attempting to entice your employees, the 401k plan participants, to sue for cash rewards. Recently, a major national business magazine actually encouraged 401k plan participants to consider suing their 401k plan trustee. Second, we find the vast majority of plan trustees who are seeking protection from participant investment losses under Section 404C of ERISA are failing to meet its criteria, and therefore no protection is being provided. This should sound the alarm in light of previous information that I just discussed. Third, we routinely find a good many of 401k plans contain excessive and inappropriate fees, of which is a trigger for litigation exploitation. Please keep in mind, typically the plan's investment advisor is normally a generalist who lacks the specialized knowledge on plan compliance and implementation. Often, the 401k plan trustee is simply not aware of this, and that's exactly why I made this video for you. Plan trustees typically rely on their vendors to help manage their plan. Unfortunately, their plan vendors do not provide the necessary guidance and proper management to bring their plans to acceptable compliance standards. Usually, the company's plan administration firm does a good job of compliance consulting as it relates to their record-keeping services, but not overall plan compliance. Please note, if your service provider is an insurance company or brokerage firm, they actually increase the plan trustee's liability exposure by protecting themselves at the expense of the plan trustees. There are only two reasons why your plan would have compliance deficiencies. First, your advisor is not aware of the plan deficiencies. Or two, he is aware, but he has simply not chosen to correct those deficiencies. Quite frankly, I'm not sure which is worse. Shocking, I know. You simply don't know what you don't know. Plans with over 100 employees will hire an auditing firm, but they only audit the plan's numbers, not if the plan is in compliance. Despite this distressing information, I would like to give you good news. The Center for Fiduciary Studies is the global authority for plan compliance. They have identified 22 best practice standards. The technical editor to these best practices is the American Institute of Certified Public Accountants. All principles are supported by ERISA, regulations, case law, and regulatory opinion letters. If a plan trustee can document they have implemented these standards, then they would have taken significant strides in meeting their compliance responsibilities. Victory Fiduciary Consulting is a 401k compliance consulting firm. And here's the good news for you today. We have created a self-assessment test for plan trustees based on the most common plan deficiencies. We call it the Employer Report Card. These 10 questions will provide a plan trustee the insight to determine if their plan is meeting basic compliance standards. I can only stress, based upon years of experience working with plan trustees, the critical importance of a second opinion. In this case, the starting point is a self-assessment using the Employer Report Card. Directly below this video, you'll notice a button that says, "Am I in the compliance danger zone?" All you have to do is click on it right now. Once you do, a new box will appear for you to enter your first and last name, plus a valid email address. When you fill that form out, we will email you the employer report card to you. Subsequently, I will be sending you a series of critical educational videos on information that every plan trustee simply must know, whether we may end up working together or not. Hopefully this information may have motivated you to take the necessary steps to determine whether you could be in the compliance danger zone. Together, we can fulfill the pristine intent of what the 401k plan is all about, providing a secure retirement for hardworking employees and employers, without the strangleholds of excessive fees, mismanagement, and bad investment choices. This is Bud Verfalli. It was a pleasure sharing this information with you today, and I look forward to serving you soon. Thank you.